it gives me great pleasure to be able to introduce our guest speakers for this annual general meeting. Dr. Virginia Torrie is a former associate professor at the Faculty of Law at the University of Manitoba. She has authored and co-authored a number of scholarly articles, as well as a sole-authored monograph, A Reinventing Bankruptcy Law, A History of the Company's Creditor Arrangement Act, which I have on my MBA course as an option for students to do as a review. And I think I've also got your new book on there as well. I have a bunch of law students in the class. A book that was published by the University of Toronto Press in 2020. Dr. Torrie holds JD and LLM degrees from Osgoode Hall Law School and a PhD from Kent Law School at the University of Kent. Dr. Torrie has been consulted as a legal expert in Canada and internationally in the areas of bankruptcy and insolvency law, receivership, federalism, statutory interpretation, legislative history, and consumer protection. Her research is cited by the Ontario Court of Appeal, La Cour d'appel du Québec, and several courts of Queen's Bench. She is also editor-in-chief of Banking and Finance Law Review and regularly presents her research at conferences and events across North America and the United Kingdom. Thomas Telfer is a full professor at Western University, the Faculty of Law in London, Ontario. He has been at Western since 2002. Professor Telfer's research and teaching interests are in the fields of bankruptcy law and legal history. He has been a visiting professor at universities in Canada, the United States, Australia, and New Zealand. Professor Telfer has published widely in the areas of insolvency law and legal history, and his previous publications include the book Ruin and Redemption, A Struggle for Canadian Bankruptcy Law, 1867 to 1919, which I will put on my list. And I think I'll probably mention it to the students this week. Published by the University of Toronto Press in 2014. He has been cited by the Supreme Court of Canada and the Supreme Court of New Zealand. Impressive, actually. That's pretty cool. Professor Telfer is the co-editor-in-chief of the Canadian Business Law Journal, which was the first place I ever published a scholarly article back in 2004 or something like that, and the co-editor of the Journal of the Insolvency Institute of Canada. It is my great pleasure to introduce these two scholars. Their presentation today comes from their co-authored work, Debt and Federalism, Landmark Cases in Canadian Bankruptcy and Insolvency Law, 1894 to 1937, which was published by the University of British Columbia Press in 2022. Please welcome Dr. Torrie and Professor Telfer, who will be speaking first.
Thank you, Dimitri, for that introduction. And I'm delighted to have been invited with Virginia to talk about our new book. I'm so impressed with this association and all the work that you've been doing. And Virginia and I are going to speak about our new book, as Dimitri mentioned, Debt and Federalism, Landmark Cases in Canadian Bankruptcy and Insolvency Law, 1894 to 1937. And I'm going to speak for about 15 minutes, and then Virginia will follow. So I'm going to introduce the book and provide an overview of the two landmark cases, while Virginia will discuss two subsequent cases and provide information on our current book project, which is a sequel of sorts to Debt and Federalism, as the story does not stop at 1937. Now, Debt and Federalism traces changing conceptions of the federal bankruptcy and insolvency power through four landmark cases that together form the constitutional foundation of the Canadian bankruptcy system. The division of powers in the Constitution lies at the heart of the disputes discussed in the book. At its core, this book is about the evolution of federal bankruptcy and insolvency power in the Constitution and its important relationship with provincial property and civil rights jurisdictions. Now, the four cases that we analyzed demonstrates that the jurisdictional gains were all in favor of the federal government in terms of Parliament, with the courts adopting a broad interpretation of the federal bankruptcy and insolvency power. In my talk, I'm going to discuss how important historical figures like Edward Blake, Lord Herschel, Quebec Premier Louis Taschereau, and Louis Saint Laurent all played an important part in the story. Before discussing the four landmark cases, it's important to briefly outline the purpose and history of bankruptcy law in Canada. Now, financial failure has been in the news with the collapse of crypto exchange FTX and its recent filing for protection under Chapter 11 of the US Bankruptcy Code. And in Canada, on this side of the border, Laurentian University became insolvent and made a filing under the Companies Creditors Arrangement Act to prevent an outright bankruptcy of the university. And each financial failure involves losses to creditors and raises a distributional question of how these losses will be dealt with. Leading insolvency scholar Philip Wood put it this way: in a bankruptcy, there's simply not enough money to go around, and so the law must choose whom to pay. The choice can simply not be avoided, compromised, or fudged. The choice cannot be avoided, compromised, or fudged. The law must always decide who is to bear the risk, so there's always a winner and always a loser. And one of the main purposes of bankruptcy law, as established by the Supreme Court of Canada, is the equitable distribution of the bankrupt's assets among creditors. And without a bankruptcy regime or something similar, chaos would simply result in a scramble by creditors. The other purpose of bankruptcy law, where an individual is involved, is debtor rehabilitation through the bankruptcy discharge and a release of debts. So how losses will be distributed and what debts will be discharged have proven to be controversial. According to the Supreme Court of Canada, the very design of insolvency legislation raises very difficult policy issues for Parliament. And Canada is a very perfect illustration of the difficulty of reaching consensus on bankruptcy policy. The historical path that led to the modern system of bankruptcy and insolvency law has been incremental and at times unpredictable. In Canada, at one point in our history, there was no consensus on the need for a national bankruptcy law. After Confederation, Parliament passed two short-lived bankruptcy statutes in 1867 and 1875. Shortly thereafter, in 1880, Parliament repealed its national bankruptcy law, leaving Canada without any bankruptcy law for a period of nearly 40 years, until 1919, when a permanent bankruptcy regime was enacted. So there just simply was no consensus on the need for a bankruptcy regime at all. But beyond the controversy of whether bankruptcy law should exist at all, was the constitutional controversies over the meaning of the bankruptcy power in the Constitution. The meaning of bankruptcy and insolvency in the Constitution Act has often proved to be uncertain, as the federal power must be measured against provincial jurisdiction over property and civil rights. The judgments in the four landmark cases discussed in this book forged the bankruptcy power at times when federal and provincial views were simply irreconcilable. Provisions of the Bankruptcy Act, the Companies Creditors Arrangement Act, and the Farmers Creditors Arrangement Act all came under constitutional scrutiny. Provincial attorney generals led the charge, arguing that the newly enacted federal provisions interfered with property and civil rights jurisdiction of the provinces. Constitutional questions that we now take for granted were very much in play from Confederation to the Great Depression. So bankruptcy law is therefore much more than a distribution of losses among creditors, as federalism cases can involve picking the winner in a dispute between Parliament and provincial legislatures over the meaning and breadth of the federal bankruptcy insolvency power. So we adopt a historical approach to analyzing four appellate landmark cases. And this historical perspective allows us to place these landmark cases into their social, economic, and political context and we consider sources beyond the four corners of the appellate decisions. The analysis therefore draws from the full appeal records, coverage from newspapers, judicial and lawyer biographies, as well as numerous archival records. We show how these four appellate decisions were both cheered on one hand and jeered on the other hand, and set legal precedents and provoked social and political change. So our story begins in the 19th century with the Privy Council decision in 1894 in the case called the Voluntary Assignments Case. So as I mentioned, Parliament had repealed federal bankruptcy law, and with that repeal, questions arose about the constitutionality of provincial debtor-creditor law. Throughout the late 1880s and early 1990s, lower courts could simply not agree on whether or not this provincial legislation for debtor-creditor law, whether it infringed upon the federal bankruptcy and insolvency power. In 1894, the Privy Council upheld provisions of the Ontario Act that had been enacted in the absence of federal bankruptcy law. And the decision had two immediate impacts. First, it enabled the provincial era of debtor-creditor regulation to continue unscathed. But second, the decision effectively stalled federal bankruptcy reform efforts for decades. Parliament would not enact another federal bankruptcy statute until 1919. Now, the Voluntary Assignments Case brought together two leading political and constitutional figures. Edward Blake was a leading constitutional lawyer of the time and a provincial rights advocate. He represented the Attorney General of Ontario before the Privy Council, and he argued that the Ontario legislation was valid because of the provincial jurisdiction over property and civil rights. As one of his biographers calls him, he's the great lion of provincial rights. The other historical figure important to the decision is Lord Herschel, who rendered the decision in the Voluntary Assignments Case in the Privy Council. Now, Lord Herschel was eminently qualified to render this decision because before becoming a law lord, he was a Solicitor General in the United Kingdom and the drafter of the English Bankruptcy Act of 1883. So he was well qualified to render this decision, and his background perhaps explains the outcome in the case. So this colonial dispute on the validity of provincial legislation had a significant impact on domestic creditors, but more importantly on English and foreign creditors. With prospects for federal reform very dim, the Ontario legislation was the best prospect for creditors. Creditors, foreign and Canadian, needed the provincial law to operate, and Lord Herschel understood that, and he upheld the provincial law, providing a short-term solution for foreign and domestic creditors. But Lord Herschel went beyond upholding the Ontario legislation. In a by-the-way comment known as obiter dicta in legal circles, it's not part of the official ruling of the case, but he went out of his way to state that the federal bankruptcy power was to be interpreted very broadly. Such statements were obiter dicta, or by the way, because there was no federal bankruptcy legislation at the time. Lord Herschel, with his background, would have known the need for a strong federal bankruptcy and insolvency power whenever the Dominion got back in the business of passing a bankruptcy law. When the bankruptcy law was eventually enacted in 1919, Lord Herschel's dicta supported a broad interpretation of the bankruptcy and insolvency power as constitutional disputes surfaced in the 1920s and 1930s, lifting the Voluntary Assignments Case into landmark status. In the 1920s, Lord Herschel's reasoning on the bankruptcy power became more important as many began to question the authority of the federal government to interfere with provincial property and civil rights jurisdiction through national bankruptcy legislation. In the 1920s, the new Bankruptcy Act came under attack from Quebec. And it would take the 1928 decision of Royal Bank and Larue from the Privy Council to resolve this constitutional controversy. Lord Herschel's dicta became the very basis of the Privy Council's decision in 1928, which is the second landmark decision I want to finish up with. Now, the outcome of Royal Bank and Larue was anything but inevitable and was not accepted, as we'll see, in certain quarters in Quebec. Given that the new Bankruptcy Act of 1919 ended provincial dominance over debtor-creditor matters, many provincial rights advocates simply doubted the validity of this new bankruptcy law. On the 18th of December, 1922, Premier Louis Taschereau rose in the Quebec National Assembly and simply declared that the Federal Bankruptcy Act was unconstitutional. Taschereau argued that the new federal law intruded upon provincial jurisdiction over the Quebec Civil Code, and he threatened to challenge the Bankruptcy Act in the highest court. He promised to do everything possible to have the Bankruptcy Act set aside and, quote, once again be master at home. So in 1923, a Quebec case arose in which the trustees of bankruptcy refused to recognize the preferred status of a provincial judicial hypothec in a bankruptcy, which was regulated by the Quebec Civil Code. The Attorney General of Quebec was quick to intervene. The case would ultimately reach the Privy Council to determine whether or not the Bankruptcy Act infringed upon provincial property and civil rights jurisdiction. The case involved the very survival of the Quebec Civil Code provisions providing for a judicial hypothec. On January 19, 1928, the Privy Council released its judgment in Royal Bank and Larue. The Privy Council relied upon Lord Herschel's statement from the Voluntary Assignments Case and ruled that the Dominion had the right under the Bankruptcy Act to postpone creditors' rights established by provincial law. In Larue, Viscount Cave effectively entrenched Lord Herschel's statement as part of Canadian constitutional law. Now, it's interesting what historical figures pop up when we're looking at these cases. And future Prime Minister Louis Saint Laurent, his law firm represented the trustees in two lower court cases, and he appeared before the Supreme Court and the Privy Council. And in the Privy Council decision, the court actually went out of its way to compliment the submissions of Louis Saint Laurent on behalf of the trustees. The day after, and I discovered this letter in the archives in Ottawa, the day after the decision was released, Saint Laurent could not conceal his pleasure at his victory, and he wrote a letter to the Deputy Minister of Justice that he felt highly elated at the decision of the Privy Council. He wrote a further self-congratulatory letter to the Deputy Minister of Justice. Saint Laurent was convinced that it was his argument on behalf of the trustees that ultimately convinced the Privy Council to dismiss the appeal. Because we don't have a transcription of the argument, his letter provides key insights into the submissions that ultimately persuaded the Privy Council. And according to Saint Laurent's letter, it was the need for a uniform bankruptcy law across the country that carried the day. Now, as you can imagine, the reaction in Quebec to this decision was not positive. In a law journal, the Revue de Droit, a lawyer published an article called simply Demolished, Quebec lawyer condemned the Larue decision as destructive to Quebec civil law. He wrote, "This disastrous, literally inexplicable decision made one more broader blow in the barrier of protection that surrounded our provincial law. Our provincial law was already quite damaged. Now provincial law, of course, falls into ruin and no longer offers us any security. How could one place its trust in it?" The Bankruptcy Act survived Quebec's constitutional challenge. The Privy Council decision in Larue in favor of a broad bankruptcy power must be considered landmark because it enunciated the principle that all judgments would have to give way to the principle of equality in bankruptcy. But Larue also is considered landmark because it ended a near 5-year struggle on the part of Quebec to preserve the supremacy of provincial rights in a bankruptcy. Throughout the 1920s, the outcome was anything but certain, and the lower courts in Quebec all decided in favor of Quebec. The Privy Council ended that uncertainty. But the story does not end here. The Great Depression had a significant impact on legislative and constitutional developments, and I'd now like to turn over to Virginia to continue the story. Thank you very much.
Thank you, Tom, and thank you to the Canadian Business History Association for having us here today. It's a real pleasure to speak to you in person and virtually. So I have the pleasure of picking up where Tom left off and talking about my favorite things as an historian, the Great Depression and bankruptcy law. So the Great Depression is this important inflection point in the evolution of Canadian bankruptcy and insolvency law. It witnesses the expansion of the federal power by defining it in relation to the debtor's financial condition, so the condition of insolvency, and distancing the concept of bankruptcy from connotations of moral culpability of the debtor. And the expansion of this federal power allowed for the addition of new modern policies to bankruptcy and insolvency law. So policies meaning objectives for bankruptcy and insolvency law. And chief among these is financial rehabilitation, which is really the overarching objective of our bankruptcy and insolvency system today. These developments are really the logical extension of voluntary assignments and Royal Bank and Larue as described by Professor Telfer. What those earlier two cases set in motion crystallizes in the Federalism case law of the 1930s. And an important corollary of this expanding federal field of bankruptcy is that bankruptcy law now starts to overlap with provincial law in new and unexpected ways. So a formerly quite narrow and constrained federal power is now clashing with robust and long-standing fields of provincial jurisdiction, most notably in the area of property rights. Provincial jurisdiction comes under threat, and as we will see, the resulting case law resolves these tensions by defining the federal power more broadly and therefore constraining what the provinces can do to address over-indebtedness within their borders. So let me briefly sketch out the crux of the constitutional debate. For a variety of reasons, and I invite you to ask me about these during question time, the Great Depression creates enormous political pressure to use legislation to facilitate the restructuring of businesses, specifically those relating to large corporations and farms. And this is as opposed to letting those businesses simply fail or relying on more informal methods of restructuring. Now, historically, some bankruptcy statutes, like the Act of 1919, had made weak attempts to provide such a facility for restructuring, but these were not particularly effective and they were very little used. Now, as any business historian will know, probably everyone in this room, a business's largest debts are usually secured against collateral of some kind. So real property, plant, equipment. And Canadian federalism at this time has bifurcated jurisdiction over the debts of insolvent businesses as follows. So if the debt is unsecured, if it's like a trade debt, jurisdiction is federal in cases of insolvency. But secured debts, like your mortgage, are provincial, even if you're insolvent. So you have different debts being resolved by different legislatures. This is truly an inconvenient place to draw the dividing line if you're trying to engage with effective business restructuring. If you want debtor rehabilitation, you really need a forum to talk about all of the debts at once, not have different debts being resolved by different legislatures. So you need to talk about secured and unsecured loans as part of the same discussion. The Canadian Parliament and various provincial legislatures bump up against this constitutional stumbling block in the 1930s in their various efforts to address the financial effects of the Depression. And in its attempt to address the need to restructure the affairs of insolvent business debtors, both corporate and farming, as I mentioned, Parliament ultimately enacts two novel pieces of legislation. So we have the very inelegantly named Companies Creditors Arrangement Act, or CCAA, and its companion statute, the Farmers Creditors Arrangement Act, FCAA. Now, both statutes are very bold pieces of legislation. They purport to make debtor rehabilitation a component part of bankruptcy and insolvency law. And the way they do this is by subjecting secured creditors to federal insolvency law on a compulsory basis. The business and financial community at the time widely thought both acts were unconstitutional and plainly overstepped federal jurisdiction, and the expectation was they would be just struck down as inoperative. In the case of the CCAA, Toronto lawyers advised their business clients against using the statute altogether, and this led Prime Minister Bennett to refer his own statute, his government's own statute, for a constitutional reference. The fear at the time they enacted it was it would be challenged. Actually, it had a chilling effect and no one would use it. So in brief and unilluminating reasons, which skirted the issue of property rights altogether, the court, in a majority decision by Chief Justice Duff, found the federal law to be valid as bankruptcy and insolvency. So in essence, Justice Duff affirmed the redefinition of bankruptcy and insolvency in terms of the financial condition of the debtor. If this company is insolvent, yes, you can adjust the mortgagee's rights. I think I got that right. Now, this decision, I really can't overstate enough how it shocked the legal community, and leading jurists thought the court got it wrong. It was such a departure from what previous conceptions of bankruptcy law had been until that time. And the financial community, too, remained skeptical and thought the court reached the wrong conclusion. Now, remember that, or you might not remember, but I'll tell you that the Supreme Court of Canada isn't the highest court at this time. The Judicial Committee of the Privy Council is the highest court. So there's a chance that if a case goes to the Privy Council, they can overturn this Supreme Court of Canada decision. So there's a lot of apprehension and uncertainty. The decision seems wrong. It doesn't align with previous case law. And a court that's not the most authoritative court has issued it. So this could be overturned. But this positive ruling on the CCAA's legitimacy is handed down at this opportune moment, just as the FCAA bill is in Parliament being read and encountering resistance from various quarters. Politicians doubted that the FCAA could be valid. It didn't seem to fit within the established definition of bankruptcy and insolvency, and the thought was it oversteps into provincial jurisdiction. And in the Commons, Prime Minister Bennett is able to hold up this Supreme Court of Canada decision saying that the CCAA is valid and using this to affirm that indeed the FCAA must be valid too. And this provided the momentum needed to pass the FCAA into law. Now, I'd be remiss if I didn't just take one moment here as a sidebar to explain what the FCAA was. This is really a singular and just plainly astonishing piece of legislation. Never before or since has Canada enacted such a muscular legislation in an effort to get debt compromises done and to keep businesses, in this case owner-operated farms, mainly on the prairies. These businesses are kept in business. It's the most progressive iteration of the policy of debtor rehabilitation of which I'm aware, in any place and at any time. And if someone knows of something else, please do message me or email me. I'd love to chat with you about it, but this is the most progressive example I've ever found. This act incentivized debtors and their creditors to make friendly compromises about the debt to keep the farm in operation. But if the friendly compromise route didn't work, It provided that a federal tribunal could unilaterally come in at the behest of the farmer and only the farmer and formulate a compromise and make it compulsory on everyone with essentially no right of appeal. And fully 2/3 of the compromises worked out under this statute came through this unilateral procedure. So this is like muscular, we're getting it done kind of debt compromise, and we're keeping farmers on farms. Okay, so let's go back to our overarching narrative. The FCAA is passed in Parliament. Now, soon after that happens, for political historians, we'll know Prime Minister Bennett loses the federal election, and Mackenzie King takes office. And King is trying to sidestep this sensitive issue of, is the Canadian New Deal valid or not? And, there's various political sensibilities here. And the FCAA is part of this New Deal. So King sends all of these statutes for constitutional reference. This is his way of, washing his hands of it. He doesn't have to align with Bennett. He doesn't have to, reject it with no plan of his own of how he's going to deal with it. Let's just let the judges decide. So the FCAA is sent along for constitutional reference, and very remarkably, it's the only piece of the Canadian New Deal that survives scrutiny at both the Supreme Court and the Judicial Committee of the Privy Council intact. This is the statute that a majority could agree definitely was part of bankruptcy law, which shocks me as a bankruptcy historian. I can't explain it. I wish I could. I have some conjectures, but nothing firm. Nevertheless, there it is, the one resilient piece of the Canadian New Deal. So both the Supreme Court and the Privy Council in the judgments of the FCAA consider the CCAA reference issued by the Supreme Court earlier as this positive precedent. The definition of bankruptcy and insolvency had been expanded during the CCAA reference, even though it wasn't the court of last resort. And while the FCAA pushes this envelope of what you can do under bankruptcy law a good deal further, including just overriding provincial property rights, it was analogous enough to what had happened with the CCAA reference that the judges seemed to rule that the FCAA is valid too. So the judicial treatment of the property rights issue is again, leaves much to be desired for scholars of legal doctrine. And into the 1980s, a full 50 years later, legal scholars are still saying the court got it wrong. You can't draw the property, you can't just come along and unilaterally adjust property rights. There needs to be like majority or something. It can't be an unelected tribunal. So it kind of died a long death there. But the Privy Council's decision, nevertheless, resolves the uncertainty and brings closure to this area of law. The decision also resolved really acute political challenges in terms of how do you provide restructuring legislation when unsecured debts are federal and secured debts are provincial. So it has a harmonizing effect there. And this means that tens of thousands of businesses and hundreds of thousands of creditors have a mechanism to deal with over-indebtedness, and businesses are kept in business to trade another day. So with judicial imprimatur, the applications to these two statutes just start to flow in. At some point, they can't keep up with the applications, especially for the farm insolvency law. So as a matter of constitutional law, these two landmark cases define the field of bankruptcy and insolvency such that legislative solutions for struggling debtors would henceforth come from Parliament and could only come from Parliament. But the provinces don't give up that easily. And Tom and I are working away on a second volume to Debt and Federalism, which carries the story forward for through mid-century, up to 1966. In essence, history is not inevitable. I'm sure I don't need to remind anyone here that that's the case. And had, this is one way things could have gone among many possible permutations. Contingency surrounded every step. I mean, in many instances, the result was the exact opposite of what one would have thought if you were kind of projecting into the future. And if any one of a number of factors had been slightly different, we probably would have had a different result. The very fact we need a second book to pick up the story is evidence of how radically the four landmark cases covered in our first book redefined contemporary notions, so much so that the provinces just didn't accept it and kept enacting legislation thinking they could respond to over-indebtedness within their borders. So very, very briefly, our second book will cover 5 cases from 1939 to 1966 in which provincial legislation was challenged for overstepping this newly expanded federal bankruptcy and insolvency power. And in essence, despite judicial affirmation of like a sweeping bankruptcy power, in the cases we've canvassed here, Larue, and then the CCAA and FCAA references, in the 1940s, 1950s, and 1960s, poor Alberta and Saskatchewan persist in their efforts to assist over-indebted businesses and individuals. And unfortunately for those provinces, all of their efforts are unsuccessful. And the cases actually had the opposite result and solidified the federal bankruptcy power. And in some cases, the Alberta legislation that was struck down is copy-pasted into federal law. So it's not exactly what the provinces were hoping for, and we're trying to work on themes, and the only one I've come up with so far there is Western alienation, obviously extends to bankruptcy law. And then the one notable exception is this case from 1939 in Ontario, which there was an Ontario statute enacted to deal with the financial distress of several municipalities, which were amalgamated into the present-day city of Windsor. And some of the creditors didn't like that, and they challenged the legislation as being bankruptcy law, and therefore Ontario can't do this. In that case, Ontario's legislation is upheld as valid and within provincial competence to govern municipalities. So kind of harps again on the Western alienation theme a little bit. So stay tuned for Debt and Federalism Volume 2, hopefully coming in 2024. Thank you for listening. If you don't yet have a copy of Debt and Federalism, we have a flyer with a discount code, and I'll read it out for those of you who are listening. The code is DEBT, DEBT 30, so DEBT 30. And this is valid for 30% off your purchase with UBC Press until February 1st. Tom and I are very happy to take questions, and if you've brought a book, we're happy to sign it. Thank you so much for listening, and we look forward to hearing your questions.
Okay, thank you. That was fantastic from Virginia and Tom.
Can we hear us if we sit?
Yeah, I'm pretty sure people can hear you when you sit there. Tom, do you want to just speak?
Yeah.
You guys can come to the front, though. I think it's best. Yeah, here's a second chair here. And I'll line you guys up here, and you can both sit. You're in front and answer questions. I'm going to let you guys do run the Q&A. Okay, so I don't have to crowd you out, because I have questions, too, that I want to ask. And I think people can hear you okay.
Okay, great. So any questions? Maybe just unmute yourself if you're, we'll give questions to the virtual room first, maybe, and then take questions from the live studio audience. So if you have a question, maybe just unmute yourself and speak up.
I wonder if you could tell us, if you looked at what was happening south of the border in the same period, whether their laws on bankruptcy and insolvency were totally different or similar, and whether or not any of these landmark cases were in any way affected by developments south of the border.
That's a great question. Tom, do you want to start with that one?
Yeah, I can start by, there's a parallel between Canada and the United States, and that the United States could also could not agree on whether there should be a bankruptcy law at all. So there's 3 very short-lived bankruptcy statutes passed in the 19th century. Congress eventually passes a permanent bankruptcy statute in 1898. So that parallels developments in Canada. The impact of sorry, did you want to pick up on that?
I don't know where you were going with that, but I might just add, so like Canada, it parallels it, but Canada gets there several decades later.
Yes.
And by the time, it's not always like an exact comparison, but it's more the kind of interaction between, the two countries. So at the time that, as Tom notes in his book, the 1919 Act, part of the problem is debtors are absconding to the United States, where there is a bankruptcy law, right? Like you're a merchant, or, we're talking about business, this is not consumers. And that's, kind of creates a little bit of impetus. Like, could we incentivize them to stay here? We'll give them the discharge, right? But, we'd rather get something than nothing, because they would kind of prefer the local creditors. And as the national economy kind of grew, that, there's more distant creditors. So that's sort of, yeah. Sorry, did I?
No, that's fine. In
yeah.
fact, there's evidence of debtors in the United States writing to Prime Minister Laurier saying, please enact a national bankruptcy law. And Laurier was just content to allow the provinces to regulate on their own without federal intervention.
And that presumably is a complicating factor in the Canadian case where the provinces are so powerful. You don't have a similar situation with the states vis-a-vis the federal government in the United States.
Yeah, it's a bit different. And then in the Great Depression, I mean, in the U.S., they have a lot of their corporate restructuring. So that's like our CCAA that I was referring to. Kind of comes out of these railroad, bankruptcies that they have or restructurings. And so they do actually have something that has very kind of similar origins, but the political backstory differs. And I'm not aware, although they did stuff for farmers, I'm not aware of scholarship that kind of sketches out something that's similar. Not to say it didn't happen, but it's kind of a unique backstory between basically Saskatchewan conservatives and conservatives in Ottawa that lead to this. I told you it's like this bold piece of legislation, but the Saskatchewan plan was worse. So from the creditors' perspective, and so I'm not aware of those exact same dynamics in the U.S., although the farmers certainly encountered similar difficulties in the Great Depression. Thank you for the question.
Yeah, thank you.
Has there been any studies on the correlation between business activity and all of this, everything from uncertainty about legislation to even enacting legislation, to tie the two together? And so, for example, did the law, was that a hindrance to resolving the depression or help minimizing the effect? Has there been studies along that line? And I'm wondering, in that sense, that correlation between business activity and legislation, could it have been the environment of the depression itself that was so severe that caused that surprising result, an affirmation of the FCAA and the CCA? Could it just have been the fact that if that decision had to be rendered in a normal economic period, it may not have been dramatically as you thought.
I can speak to the business activity perspective, at least in terms of the Bankruptcy Act, because the Bankruptcy Act was operational in the Great Depression. And when I initially looked at bankruptcy statistics in the Great Depression, I expected a significant rise in the number of bankruptcies through the Great Depression. In fact, that's not what happened. Bankruptcies actually declined throughout the Great Depression, which shows you the real slowing of business activity, that you weren't having the same number of businesses. And it's only in the late 30s does the superintendent of bankruptcy notice that as economic conditions are improving, the bankruptcy rates start to rise again.
And then the Great Depression, I mean, I think your point's really well taken, right? Like in normal times, what would you be prepared to do for bankruptcy, and in the Great Depression, what would you be prepared to do? The difficulty I found, and I don't dismiss it as, I think it does factor in, but it's hard to pin down because the rest of the New Deal was also important to Canadians in the Great Depression, right? So, it is like unemployment insurance, is a no, but bankruptcy is a yes. I mean, it's hard to get those four decisions to fit together in any kind of sensible way. I've speculated on other things, like law lords had a very particular attitude toward debt, and also farmland. So, maybe that's sort of like, but it's really the realm of speculation because I don't have anything concrete to really tie that down. But certainly, like the impetus for the CCAA is actually just, it happens to coincide with the Depression, but there had been kind of changes in how companies were financed that necessitated those changes, and it's just everyone's bankrupt at once, so like all of a sudden you have to do something, right? So it's like a catalytic kind of event. With farming, the Great Depression is certainly a factor, but the bigger factor is really the Dust Bowl and the climactic conditions, right? Like the 20s are this period of abundant harvest, especially in the Pulsar Triangle region of southern Alberta and Saskatchewan, and a lot of, kind of people getting into farming or expanding their operations. And certainly, like the Great Depression doesn't help them at all, but I think you probably would have had that pressure even without it, just because of what was happening out there and the destitution that people experienced. And that just created enormous political pressure. I mean, that's almost an understatement, but like Saskatchewan's the third most populous province. And they were on the cusp of making it impossible to ever enforce a debt in Saskatchewan, which Prime Minister Bennett thought, you will destroy Canada's credit if you do that. He had just very carefully prevented Canada from defaulting on its debts to foreign creditors in 1932. And his like conservative, because there's like conservatives in Ottawa and in Saskatchewan, I encountered these coded telegrams in the archives, thankfully with uncoded versions, so I could interpret them. And they're basically saying, you know, like, they kind of keep going back to Bennett and saying, you have to do something federally. That's the only way we're going to prevent Saskatchewan from going this way, because it's all farming. And eventually Bennett realizes that that's a really imminent threat, and he calls together, you know, the big creditors into the PMO and says, like, we have to hammer something out. And what we get is this like incredibly progressive statute, but it's less progressive or less far-reaching than what Saskatchewan would have enacted. Now, the downside of that, it's almost impossible to borrow money in the prairies for decades after that's passed, right? So,
Sorry, I didn't hear that. It's almost impossible to which?
borrow money for farmers in the prairies after that, after all of those bankruptcies are processed, right? So, like, it's strong, you know, it's necessary, or, you know, like it served a purpose, but there were real repercussions of doing that, right? Like, people really thought twice about if they're going to lend to farmers, you know, after and just are like, you know, be like the Royal Bank, and they've just said the farmer never has to pay you again. Bad debt, write it off, right? And you've no right of recourse. So that, yeah, I think I meandered a little with your question, Mark, but thank you so much for the question. I hope that's enlightening.
There's a hand.
Okay, Eric, nice to see you again.
Yeah, nice to see you. Is there any quantitative work on just how much? Sorry, a lot on how much debt was rescheduled. Like, how much are we talking about in the FCAA?
Yeah, you're saying quantitative?
Yeah, can you put numbers to it?
Yeah, I can't remember them off the top of my head, but they did try to keep meticulous records, and so there actually is there was an annual report of how much debt was written off. And then a kind of a final report that was kept in Ottawa. So if I can share that information with you, I kind of put
It's in the millions.
It's in the millions, yeah.
It's in the tens of millions?
Yeah. And they have to do the inflation adjustment, right? But they did keep very detailed records to the best they could, and they did keep track of it. And Bennett was very keen on highlighting, like, let's segregate this by, you know, which ones were voluntary, you know, arrangements, and then which ones did we force people to accept. But I mean, they're huge numbers for the time, for sure.
Did you collapse the home bank? And did it have any impact on it? Because they were very traded with the farming community.
Not that I've encountered in this study. I mean, banks didn't lend on a secured basis at that time, so their loans to farmers were smaller, right? So, like, if you had a mortgage or a equipment loan, it wasn't from a bank, and banks don't get that power until much later. So those loans would be more in the vein of trade credit, or, you know, kind of smaller amounts. So not that didn't hurt them to, like, you know, not get their money back, but you know, the entities that would have been harder hit would have been the ones with the big debts.
It must have put poor old R.B. Bennett in a hell of a pickle, which to on the one hand, to be on the side of the farmers and hurting the Royal Bank. Yeah.
Yeah.
I'll have to look at the RBC history to see what they say about this.
I remember at one time, just as an anecdote, I think it was the Royal Bank, but it might have been one of the other big banks. At one point, they, you know, because these are detailed files, like, they didn't keep every single file, but the ones that happen to be preserved can be quite thick, and you read through that correspondence. And at one point, they had, like, you know, say it was a $50 loan from the Royal, and they decide we're writing it down to $2. And, you know, we're also extending the timeline for repayment over the next, like, 10 years. And the Royals, you know, bank representative writes, it's like, you know, it's really not, it's more expensive for us to keep this open for 10 years than to just write it off. But, like, you know, it didn't change the outcome. But, you know, this is this is how it worked with some of these unilateral compromises. And I think it did kind of refine some of those rough edges, but in those early days, it was just like they didn't have enough forms, right? Like farmers were coming in like in droves, like tens of thousands in such a short time that they just couldn't keep up with the caseload in the early days. So they tried to keep records. I'm not going to say they were 100%, but I think in those early days when they were doing this, it was just a little chaotic. And that's interesting in itself.
I don't know if there are other virtual questions, because I'm happy to defer. I don't know if Eric had a follow-up. So I had a quick comment and a couple of questions. I keep thinking about this being the inverse of too big to fail. They're all too little to fail. And you've got to keep them going because the implications are too dramatic for a weak economy. A weak economy, that's the other kind of a bigger thing. So too little to fail works out for a lot of these guys, and they end up doing it. So in a previous life, I was a research assistant on Jack Saywell's The Lawmaker's book for about 7 years. And I taught for him. The narrative is always, he hated Haldane and Watson and all those guys, and the JCPC is always screwing the feds, coming out on the side of the provinces. And then, yet in the middle of this craziness of the New Deal cases, where they do basically come out on the side of, there's this outlier, this crazy outlier, right? And it's bankruptcy law. And, you're speculating on reasons for this. But isn't it the case even more kind of unusual in the context of just how many wins they've given the provinces since the 1890s or whenever the hell this winning streak has been going on, and we're at our watertight compartments and all that crap? I mean, doesn't it seem even more as a political as opposed to a legal thing of being just so unusual in terms of their decision? And we don't have any record of the decision itself, like.
We have the decision, but not like their thinking, their reasoning, or their thinking. Not that I've been able to find.
What are their arguments?
We looked in London at Kew. We looked in the LAC, but I couldn't find anything.
And who was the deciding judge on that? It was,
I don't.
Herschel. He's gone from there.
I'm not sure who was on the FCAA. I'm not sure. It was different judges. I don't think there was much overlap. We kind of, Tom, I think in the early days we tried to look at, was there a lot of the same judges deciding? And the only one that now I think of, because we write about it in the conclusion, is Chief Justice Duff. Who's
on the Canadian side.
Well, yeah, on the Canadian side, but he was a privy councillor for a very long time, right? So he, there's like a real affinity there. He understood their style of judging. He was really well regarded by the law lords. He also almost went bankrupt himself, so it's an interesting speculation. He's a very unlikely hero for Canadian bankruptcy law, but he is this sort of anti-hero in the story. And he comes out, he's like a real strict literalist, and then he just ignores secured creditor rights, right? I can't explain it.
Where does it come from?
But I can say that, the contradictions in the cases bear a resemblance to the contradictions in the man. And I have to kind of stop there for scholarly rigor. But I mean, it's perplexing, and I keep kind of coming back to it, but I don't, other than speculations, I don't have anything concrete. And I can't even tell you the conservatives are pro-bankruptcy. They were because they needed to, and they were in office at that time, but it wasn't, Bennett didn't want to do farm insolvency law, right? He didn't want to do the CCAA. It was just circumstance forced his hand in a way where, he cared too much about the economy.
It's a bailout.
Yeah, it forced his hand, but it wasn't he wasn't setting out to do this as the, part of his political platform.
So that leads to my second question too, because there's a lot of politics involved here. What is the business lobby or business people saying about this at this time? Because they must be having their own pretty sharp views on these pieces of legislation and what's going on with them. And I can't recall from your remarks whether you talked about that. But is there any discourse around that in terms of in the press or perhaps where discussions are being had with political leadership around what the hell's going to happen and why this legislation and where it's going to go? Is there pressure from business?
Tom, do you want to start with the 1919 Act or the Larue? I think you touched on the Quebec, but I don't know if there was...
Yeah, I would say in the 1919 Act, because there's 40 years, nearly 40 years with no bankruptcy law. And there was the actual Bankruptcy Act of 1919 was drafted at the behest of a lobby group, the Canadian Creditmen's Trust Association, retained a Winnipeg lawyer to draft a uniform bankruptcy law. Without that initiative, I don't think the federal government would have got back in.
Sort of like Alec. Those peasant states.
Yeah, so it was a private initiative to get the legislation before the government. Eventually it was picked up as a government matter and passed. But there's an example of a lobby group pushing for national uniform legislation because of the diverse provincial laws.
Right. And the federal government, it seems wildly disinterested in this for many, many decades.
Yes.
They remain disinterested today. In the Great Depression, there is business talking about it, but they're really, the constitutional question makes them think like there's just not a way forward, right? Like we have to, the way they were thinking about those watertight compartments, like there was just no way. In the case of the CCAA, it was really like big investors, like Canadian life insurance companies that had a stake there. That actually, to attract U.S. finance, they had like a restructuring provision in their trust deeds when they issued bonds. To attract U.S. finance, they took that out. And then they didn't realize that left us with no way to restructure in Canada. And so they, well, what do we do? Because this was like literally provincial law. And then Bennett, who's, quite an investor himself, right? I don't know how he came to it. Maybe it was just his own idea, but he decided to put together this legislation, which is copy pasted from provincial law, essentially, private documents under provincial law into a federal statute. And the business community reported on it, like in their kind of yearbooks of trade associations, and said it's unconstitutional. Like we will not make submissions because all we can say is it's unconstitutional, but we desperately need it. So they're kind of conspicuously absent, but kind of tactically so, because they know something has to be done, but they don't have a better plan.
Unconstitutional saving, like they did with EI or UI, constitutional amendment to make it a national thing. I mean, they could have made bankruptcy. They could have actually done something, but it was so impossible to do.
It was impossible to do, and I think just Dominion provincial relations were really strained. And then on the farm stuff, I mean, I've kind of alluded to that before. The business community was terrified of what Saskatchewan was doing, but so were the politicians, right? But they were going to lose their seat if they didn't do it. And Bennett just calls in these business leaders and the people who have kind of skin in the game into his office and kind of persuaded them that, like, we can't do nothing. Like, we have to do something or the alternative will be worse. So he kind of played a role there.
The interesting thing about Bennett, there's a book of letters, edited letters called The Wretched, where individual destitute debtors would write to Bennett and ask for money. And in this private correspondence in the archives, you can see him writing to these debtors, enclosing a check and giving them money.
Yeah.
Here's a tougher question.
Oh dear.
So we've got to think about the great Canadian public. So my question is, I was very much taken by the phrase moral culpability of debt, kind of very moralistic view towards debt. So during the Depression, I'm wondering if, since it went on for a long time, the public attitude towards debt changed, meaning from it's a moral matter, and if you can't pay your debt, you're a bad person, to we're facing terrible climate, we're facing the business cycle, everybody is having problems with debt, huge percentage of the population. So was there greater acceptance of debt in the public mind as a result of that?
Absolutely, yeah. Especially on the prairies, in farm communities, like farmers survived on credit, and like a lot of general stores, like you'll hear this story if you talk to folks from, my great grandfather or whoever had a general store and kept those farmers, kept extending credit through the Depression. So it definitely becomes much more normalized. Everyone's poor and they don't know it, right? Like you're all in it together. So it definitely does. But, it still had kind of tragic consequences, like there's suicides and there's sort of decisions taken not to report those always, but like things are so bad.
It's not an analogy, but it's sort of like COVID, where restaurants, not dozens, but hundreds, thousands went out of business, and there was no real shame.
Exactly.
Because everyone faced this terrible set of circumstances, understood why someone, they had to close the doors, they couldn't get products, they couldn't get work, whatever.
Yeah, and that comes up in the debates on the Farmers Bill for sure, and there's a lot of talk about that, and politicians are sensitive, and they talk about it. Like, these are people who are workers, they want to work, but everything is stacked against them, right? Like, they need a second chance.
Wasn't there politically a rise of populism at the time?
Yes.
Which would have been and I'm also thinking that Canada was shifting from relying on the UK for much of its credit to relying on the US for much of its credit.
Yeah.
I'm wondering if that had a role, because the perception, as I understand, and I'm not an expert, in the UK is that debtors are debtors. And you go to debt prison, you pay. Whereas in the US, it's like more populist. Oh, well, if I don't pay, I don't pay. I can walk away from my mortgage and so on.
Yeah.
So was it shifting as a result of that shift as well, of reliance on creditor from the UK to the US?
Yeah.
Is it shifting the perception of debt?
Yeah, the perception, I think there is sort of a real sense, certainly in farm insolvency, of having that kind of shared experience with the American farmers of that time. And there's a lot of kind of correspondence between Canadian farmers and farmers as far away as like Australia, right? Like it's, you don't think of that, that they had those sort of connections, but I've seen letters going back and forth and really an effort to mobilize. And so I'm sure there was sort of some cross-pollination there. In terms of the shift from British capital to US, that shift is exactly why we ended up needing the CCAA, because we had followed this British convention of financing through trust deeds with these restructuring provisions. And in the US, they were very skeptical of those. And so as Canadian industries, especially pulp and paper in the 20s, really start to get US investment, the investors say you have to take that out. Like, I can't, but unlike the US, we didn't have another way to do it. And that, what's also very interesting though, because kind of to that, I'm kind of riffing off of your point. So after the CCA is passed, I told you everyone was skeptical. It passes. What did the Canadian companies do? They restructure and use it to reinsert the old way of restructuring into their trust deeds, which is significant because by that point, if you do that, you can't list your bonds on the New York Stock Exchange. So they voluntarily opted out of US markets to return to what they were comfortable with, and then raised funds, interestingly, mostly domestically for the next little while, with some UK investment, but UK investment never kind of, ended up resuming its status as sort of the dominant.
They're going bankrupt by the time themselves.
But interesting, in terms of US or UK influence on bankruptcy law, it was the drafter, Winnipeg lawyer who drafted the Canadian Bankruptcy Act, followed the English model rather than the American model. He was concerned the American model was too liberal in terms of the discharges and release of debt, so he followed the very conservative English model to make sure that there was more control over the discharge through court supervision.
Yeah, so some influence from the US, but maybe not as much as the British legal roots were still pretty strong at that point, I think. Thank you for the really excellent and stimulating questions. You guys have brought up kind of aspects or perspectives I hadn't necessarily fully turned my mind to. So it's really always a pleasure to hear.
Well, if there are no other questions, a round of applause to an excellent presentation.
Thank you. Thank you for the questions.
Thank you.
Okay, I'm just going to actually just say goodbye to everybody and sign off. If you guys won't mind me just...
I think there might be a hand there, Don.
Oh, okay.
I don't...
Did I miss a hand? Don?
No, I was applauding.
Oh, okay.
Okay.
It was an applause hand. Okay. Well, thank you very much. And again, thank you to Virginia and Tom for a pretty fantastic discussion and some great questions. And if people do have additional questions, if they didn't have a chance, you can find them online and ask them additional questions as well. And with that, we're going to conclude the annual general meeting of the CBHA for its 7th year. Thank you so much for everyone who was able to participate and attend. All of the proceedings have been recorded and will be, with the permission of Virginia and Tom, the presentation as well will be on the YouTube channel for the CBHA, so people will be able to access the talk, and it is pretty fascinating, especially for people who are interested in the connection between business and bankruptcy and the law, in this case in Canada, and from a historical perspective. So thank you very much, and with that, I will say goodbye to everyone, sign off, and thank you again for an excellent year, and we look forward to another year next year for the CBHA. Thank you.